the need for interpretation. So I think this really underscores the need for interpretation. Now I come to two important slides which deal with theories and doctrines, and then I'll go into the how these have been applied by different cases. Now let's go to the theories. There are broadly 7 theories which we have called out. One is the textualist, which says just go by the plain meaning. Don't go to the Constituent Assembly debates. Don't go to the history. Don't go to what was discussed in Parliament, what was contemporaneous at that time. Simply put, no text, no external aids. Just take the text and interpret it. Of course, the classic example is, of course, A.K. Gopalan. Then the earlier cases on 368, which I'll come to shortly, where they simply interpreted the text and said, when the meaning is plain, why should we do anything else? But as you'll see in a constitution, you're not interpreting a sales tax law where you can go by the plain meaning. You have to necessarily go into other theories. Next is the originalist theory or the historical theory. The classic illustration of this is the famous book by Robert Bork on the original theory, the original intent, as he calls it. To put it simply, what it requires is you put yourself in a time machine back in 1950 and find out what the federal constitution would have intended, and then interpret or answer your problem accordingly. The third is doctrinal, where it's pro-precedent. Basically, it places great emphasis on following earlier precedents, and it seeks to avoid departures unless absolutely necessary. The fourth is very, very important. It's structural. Structure is, what's the structure of the constitution? What is the arrangement? How are the powers divided? Separation of power. What is, if I may put, the architecture of the constitution? That has to be borne in mind while interpreting your constitution. The fifth is prudentialism, where they try to see what is the cost and benefit involved. That is, if I interpret it this way, what would be the implications? If I interpret it the other way, what would be the costs and benefits? So basically, it's a kind of a trade-off situation where you try and see how the constitution has to be interpreted. The sixth is, which has got a lot of traction recently, is the purposive interpretation by Aaron Barak. He was the former Chief Justice of Israel, a brilliant author. And in his book on purposive interpretation, there is a complete chapter on constitution which bears careful reading. Seventh is ethical. Philip Bobbitt, in his book, he points out ethical is not something moral, immoral kind of situation. When he talks of ethics, he means what is the character of the constitution? What is the ethos of the Indian constitution or the US constitution? And the interpretation which promotes the ethos of that constitution should be followed. Let's go to the next slide, please. So these are the 7 theories. And before I go on to doctrines, I was told that in Yale, when Professor Akhil Amar gave lectures, my friend Janvi Sindhu tells me that he used to say that these theories are like strands of a rope, and you strand them together, and then this is how you can interweave these theories to answer a particular problem. So that's the importance of theories. From theories, we go to doctrines. Now, I'll go through them quickly because I have to finish in 40-45 minutes. First is the colorable legislation. The classic example was the initial thing of Gajapati Narayan Dev, where colorable means that you ostensibly are trying to show that your law is within the parameters of the constitution, either in terms of competence or in terms of limitations, but actually you are violating the law. In other words, you are doing indirectly what you can't do directly. One was the common example. I've just taken 2 cases. There are quite a few of them. One is the Bombay Tenure Abolition Act, where ostensibly they tried to deal with tenures, but in reality they were dealing with the compensation or the rights of the tenure holder. So they said it's a clear case of colorable legislation. The more egregious example and the better example is the Bihar Ordinance, where ordinance is to be passed only for emergency situations. But this DC Wadhwa's case, where they found that the Bihar government had the repeated practice of passing an ordinance, allowing it to lapse. The moment the Legislative Assembly session got over, again re-promulgate that ordinance again and again and again. And that in a very good judgment by Justice Bhagwati, he says it's a clear colorable case of power, and they use the word, it's a fraud upon the constitution. That's what they say. It's a fraud on the ordinance making power. Pith and substance is very important. One is, it's basically applied in interpreting legislative entries. A law apparently comes under list 1, but it has got overtones or some shades of list 2. Now, is it ultra vires parliament's power? And there you go into the pith and substance. What is the real nature of the matter? And if there's incidental trenching, you don't really bother, the law will be still valid. For example, I abolish or I give relief to agriculturists. What am I doing? And those, suppose, for example, those loans are based on promissory notes and negotiable instruments, and I waive those loans. Then am I dealing with negotiable instruments or am I dealing with money lending? So the pith and substance, it's for debt relief for agricultural indebtedness, and it falls within list 2, and therefore it is valid. Incidentally, it deals with other points it doesn't really. There are a number of cases. I want to tell the audience that aspect theory, which has been come down, I personally feel it's a completely mistaken notion which our Supreme Court has introduced into our Constitution. If you read the history of the aspect theory, where it came from the Privy Council, dealing with the Canadian law, where they say that a particular law may have a provincial aspect and may have a federal aspect, a union aspect and a state aspect. Then they go on to say in the next 2-3 paragraphs, when it has different aspects, you find out what is the main feature of the Act, what is the pith and substance of the Act. If the predominant feature is a federal feature and not a provincial feature, then the parliamentary law prevails. Unfortunately, we have taken aspect theory to be a separate theory, separate doctrine. You must understand that it is a subset of pith and substance. A law has different aspects. Find out what is the predominant aspect and then apply pith and substance. So the judgment in the federation case, in my humble opinion, is completely wrong. Go to harmonious construction that all of us know. You have two conflicting provisions.